thank you very much, entire LJRF voice team, Akshay Raj and Kavya, Rajiv, the editor in trainee, and also Rahimat, the LJRF Center for LJRF Center for Women and Child, and Akshaya, member LJRF Center for Probation Reforms. And I also thank Dr. Lowell Mansar, my co-presenter, and also Shanmugam Pillai sir, who is present here, Secretary Achuthamenon Foundation, and the conveners of different committees of Law and Justice Research Foundation, and the dear participants. So now we are dealing with the most important topic that so many areas were discussed and by Lowell Mansar, but I think you can see some of the important news reported by the newspapers in all over India, especially. You are seeing a particular PPT picture which is published by Hindu, that DMK seeks supports for recalling a TN governor, and also in the Telangana governor defends decision to go slow on pending bills. And also the similar situation is there in the state of Kerala. Kerala governor and the government duel over the minister's stock. And there was a clear conflict in between the Kerala governor and the ministers, Council of Ministers. And it was a very disturbing factor for the since 2-3 months. So, so the people are eagerly waiting, and they are trying to understand what is actually the constitutional position of the governor and the chief minister, whether the governor is right or the chief minister and the chief minister headed by the council of ministers headed by the chief minister is right constitutionally. So we are the governor is also interfere on the many aspects, not only in the constitutional governance, but also interfere on the individual's freedom, like for example media right, because there was an agitation by the media that their rights are infringed by the governor. So we are discussing all these things because Lowell Mansar already explained the various provisions of the Indian Constitution, which are closely and directly and indirectly dealing with the functions and powers of the governor is concerned. We are discussing this on the basis of two important documents. And the one document is available in the Ministry of Home Affairs, Government of India. And in their website, when you Google the Ministry of Home Affairs, Government of India, you will get a result that is a Sarkaria Commission. And Sarkaria Commission is a very important commission which discusses the central and state relationship, and which was a very comprehensive inquiry of the relationship between the central and state relationship. And second document, of course, is the Constitutional Law of India that Lowell Mansar already mentioned. So I am analyzing this position of the governor on the basis of these two documents. These two documents are equally very important documents, the Sarkaria Commission report and the Indian Constitution. So when you're considering governor, Lowell Mansar already explained, when the constitutional position of the governor is concerned, a governor is appointed by the president under Article 155 of the Indian Constitution. And the governor shall be part of the state executive, and the governor shall also be part of the state legislature, which has been mentioned under Article 163 and Article 168 of Indian Constitution. So the constitutional position of the governor is that the governor has executive functions, legislative functions, quasi-judicial functions, and all these functions of the governor are subject to the aid and advice of the Council of Ministers, as Lowell Mansar already mentioned. The Council of Ministers headed by the Chief Minister, unless otherwise provided by the Constitution. That is a very, very important point, unless otherwise provided by the Constitution. So unless otherwise provided by the Constitution, every functions of the governor, executive, quasi-judicial, legislative functions are subject to aid and advice of the Council of Ministers. Why it is so? Because of the simple reason that the Indian constitution is essentially a federal constitution. As we already learned, the fact that the Indian constitution is federal in nature and quasi-federal in spirit, and that federal in nature and quasi-federal in spirit is actually the basic structure of Indian constitution. And another important point that is considered to be the basic structure of Indian constitution is actually the parliamentary form of government. So it was these two important concepts are basic structure of the constitution, and that doctrine was developed in 1973. And you know that important judgment of the Honorable Supreme Court, 13 judge bench of the Honorable Supreme Court, the Keshavananda Bharati versus State of Kerala. So we have to analyze and understand the powers, functions, and privileges of the governor by analyzing the nature of the constitution. The nature of the constitution, two important nature of the constitution is Indian constitution is federal in nature and quasi-federal in spirit, and the form of the government is parliamentary form of the government. So that is I think it is a very important thing. So the functions of the governor is, I already mentioned that the governor is also bound by the rule of law, and the rule of law is the basic structure of Indian constitution. So without a constitutional provision or without a statutory provision, then the question is, Lawman sir said, whether the governor can exercise discretion. Yes, of course, the governor can exercise discretion, but the exercise of the discretion of the governor is subject to the constitution and other laws. Without a statutory support, without a constitutional support, governor cannot exercise his discretion. So that is another important point. So when you analyze this, it is based on there was an observation, and that observation was made by Dr. Rajendra Prasad. Dr. Rajendra Prasad in the Constituent Assembly, that it was his statement that nowadays, because of a difference between the various political parties and members of the same party, the people of every state are troubled by the political situations and the party politics. So I think this statement is still relevant after 75 years of our independence. They do not have the same confidence in politicians as they once had. It is necessary, therefore, that the people of the state should have full confidence in an institution like that of a governor. So this is a very important point. It is necessary, therefore, that the people of a state should have full confidence in an institution like that of a governor. So a governor should be free to deal with the situations according to his best judgment, keeping in view of the Constitution first, and the rule of law second, and the convention of the parliamentary system of the government, which is then later declared as one of the basic structure of Indian Constitution. So I am asking these important questions by analyzing these two important documents. One is the Sarkaria Commission report, and second one is the Constitutional Law of India. Do we need a governor post? Second question is, do we need the same governor in more than one state? Then does he need special privileges guaranteed under Article 361 of Indian Constitution? Does he need any qualification? Does the state government need any say in his appointment? Does he eligible for reappointment? Does he eligible for new assignments? Because all these questions are discussed and debated in the Constituent Assembly. All these questions are discussed and debated in some of the important judgments of the Honorable Supreme Court. And all these questions are discussed and debated in the Sarkaria Commission report. So the first question is, do we need a governor post? That is the first question. So when I analyze Indian Constitution, yes, the answer is yes. Why? Because of the simple reason that I already explained that Indian Constitution is federal in nature and quasi-federal in spirit. So in order to strengthen the quasi-federal nature of the Constitution, and in order to strengthen the federal nature of the Constitution, a governor is essential. That is what the Lawman sir said. He has a dual. He has two faces. because he's an agent of the central government. At the same time, he is an integral part of the executive and the legislature of the state. So that is one of the reason why constitutionally, whether a governor is needed or not, it was discussed in the Constituent Assembly. In that particular discussion, there was no doubt that the entire Constituent Assembly said, yes, there we need a governor, because this is a concept, as Lawalman sir said, it has incorporated from the Government of India Act 1935. Earlier, it was there in the Government of India Act of 1858. So the Constituent Assembly said there is two important points discussed: whether we need a governor, and then what kind of appointment that a governor need. As per Indian Constitution, the first discussion, there was a discussion that we need a governor like the United States of America, that a governor who is appointed by the people, or the governor who is elected. And then the second argument was we need a governor, and he is appointed by the central government. So at last, we decided to appoint a governor. We constructed a constitution in such a way that these appointment of governor, the power to appointment of the governor, then vested in the hands of the union. So, do we need a governor? Definitely, we need a governor, because of the simple reason that the nature of the constitution demands the appointment of a governor, because it is also specifically mentioned under Article 355 of the Indian Constitution. Because what Article 355 of the Constitution says, it is the constitutional duty of the central government to protect the state from external aggression, internal disturbance, and also to see that the government of the state is working according to the provisions of the Constitution. So actually, in that regard, the governor is actually a watchdog of the central government. But at the same time, when you are considering the parliamentary form of government, the governor is bound by the aided advice of the Council of Ministers, and in the executive actions and in his legislative action, as Lawalman sir already mentioned, Article 200, which is mentioned under Article 163 and Article 200 of Indian Constitution. So because of this parliamentary form of governor, you know that governor is essential, but the governor is only a nominal head of the state, and and he is also an agent of the central government. But the real executive power is vested in the hands of the Council of Ministers headed by the Chief Minister, because of the simple reason that we are following the parliamentary form of the government, because the nature of the government, as mentioned by Dr. Ambedkar in the Constituent Assembly, that our nature of the government is the parliamentary form of government. So, therefore, I would say that the governor's post is essential. But the governor has a dual function to do. He's an agent of the central government, and he has an active participation in the executive and legislative process with the aid and advice of the Council of Ministers. That is a very, very, very important point. Aid and advice of the Council of Ministers, and the need for the governor. What is actually the people and the Constitution expect from the governor? Because Constitution is actually people's document. So what the Constitution expects from the governor is, governor must be a unbiased, independent, impartial, and governor must always be above party politics. That is what the constitutional expectation of the governor. So that is the first question. Then the second question is, do we need same governor in more than one state? When you analyze the constitution, we don't need a same governor in more than one state, because we need to change some of the ideas which are there in the constitution, because it was created because you know that our constitution was created in 47, many of the ideas we incorporated from the 50% of the ideas of the constitution was incorporated from from a single statute, the Government of India Act of 1935. So where the governor is specifically mentioned, and we incorporated so many things from that Government of India Act. So the question is, because you know that this particular provision that the one person can be, or one governor can be act as a governor of more than one state, has been incorporated in 1956 by way of a constitutional amendment. So what I am saying is, the question is, do we need same governor in more than one state? And my answer is no, because we don't need a same governor in more than one state, because it is a very responsible constitutional institution. It is unfair that the appointing the same person as a governor in more than one state. Why? It is because it will only pave a way for corruption, favoritism, and nepotism, because constitution does not impose any specific qualification for the governor. That is the most important thing. The constitution does not prescribe any specific qualification for the governor. As law elements are already mentioned, that article is Article 155. What is the qualification prescribed in Article 155? It is only two qualifications. One is he is attained the age of 35 and he is a citizen of India. That is actually not a qualification. That is normally happening naturally. Every citizen, as far as citizens are concerned, they attain the age of 35. It is not a qualification. So that is one of the reasons. I think that is the most important thing, that he does not possess any genuine qualifications. So that is one of the reasons why I am saying that one governor cannot be appointed more than one state. And also because the constitution does not impose any specific qualification for the governor. Therefore, any person having no skill and no sufficient legal knowledge can be appointed as a governor in more than one state. What is the consequence? He will be a burden for the people of more than one state. That may be the result when that kind of appointment is initiated as per the constitution. But the constitution saying that a person can be appointed as a governor in more than one state. But what I am saying that it is wrong. And then the third point, the third question, does he need special privileges guaranteed under Article 361? In my point of view, there is no need for such privileges, because of the simple reason that this country is a country which is governed by a constitution which established rule of law under Article 41 of the under Article 14 of the Constitution. Rule of law means equality before law and equal protection of law. See Article 361 of Indian Constitution, which give privileges to the president, the governor, and Raj Pramukh. But the privileges of the Raj Pramukh, we repealed that provision in 1956. So why I am saying that he is not entitled to, he does not reserve that privileges. He does not deserve that privileges because of the reason that see the president, whether the president deserves the privilege, yes, of course, because of the reason that India is a republic, and the president of India is an elected person, and he is elected in a democratic way. So the simple reason that the president need that particular immunities and privileges guaranteed under Article 361 of the Constitution, because of this simple reason that his voice, the voice of the president is the voice of the people, because he is elected in a democratic way. See the appointment of governor. Whether he is an elected man, no. Governor never have a voice of the people, because of the simple reason that he is not an elected in a democratic way, but simply appointed by the president with the aid and advice of the Council of Ministers of the Union. So in my point of view, there is no need for any privileges guaranteed by under Article 361. The governor does not deserve. That word is correct, I think. deserve that privileges as mentioned in Article 361 of the Constitution. I am not saying that the president can a president is entitled for that privileges because of the simple reason that India is a Republican country. But these governors are not deserving that privileges. Anyway, that is my contention. Then the next point is, does he need any qualification? So the qualification is prescribed in Article 155. That the question is whether that qualification is enough. So the answer is actually this, because the Sarkaria Commission report, and in that particular report, in chapter 4 is entirely dealing with the role of the governor. So you please read chapter 4 of the Sarkaria Commission report that I already sent in your WhatsApp. I already sent that report, and that report is available in the Government of India website. And in that particular website, one of the chapter, almost 40 pages of that chapter deals with the role of the governor. And in that particular chapter, it is specifically mentioned that a person to be appointed as a governor should satisfy the following criteria. He should be an eminent in some walks of life, and he should be a person from outside the state. He should be a detached figure and not too intimately connected with the local politics of the state. And he should be a person who has not taken too great a part in the political, generally and particularly in the recent past. So this is something which is prescribed as qualification by the Sarkaria Commission. So then the question is, so there is no doubt about it, the governor needs some qualifications. Governor needs some specific qualifications, as specifically mentioned by the Sarkaria Commission report. And then the question is, does state government need any say in his appointment? Does state government need any say in his appointment? Because of the simple reason that the federal structure of the Constitution is the basic structure of the Constitution. So for the answer is specifically mentioned in the Sarkaria Commission report. Because in the Sarkaria Commission report, there was a 2 recommendation. And what are the 2 recommendations? The first recommendation was a National Presidential Council should be set up to advise the president on the matters of national interest, inter alia, for selection of a person to be appointed as governor. This council should be analogous to the Council of State originally proposed at the time of framing of the Constitution. It would be composed of the composed of the Prime Minister, that is presiding officer, and the leader of the opposition in the 2 houses of the Parliament, former president, prime minister, former presidents, former prime ministers, and the Chief Justice of India, the Attorney General of India, and a certain number of nominees of the president. So this particular National Presidential Council, that council has a composition, and the council has to select the governor, and the council has to advise the president to appoint that person as a governor. That is one recommendation. And the second recommendation is that it is desirable that a politician from a ruling party at the union is not appointed as a governor of the state, which is being run by some other party or a combination of other parties. So there was a clear-cut recommendation, and that recommendation is available in chapter 4, that in order to ensure, as far as the second recommendation is concerned, in order to ensure the effective consultation with the state chief minister in the selection of a person to be appointed as a governor, the procedure of consultation should be prescribed in the Constitution itself by suitably amending Article 355. Because Article 355 of the Indian Constitution deals with the appointment of president. As already Lawman sir said, the governor is appointed by the president by the advice of the Council of Ministers. But at the same time, the Sarkaria Commission report saying the fact that when the governor is appointed by the president, he has to consult also with the chief minister of the state. So these are the two recommendations. So what I am saying is, yes, does state government need any say in his appointment? Yes, definitely need. Otherwise, they can opt the first option, because there is a transparency in the appointment of governor. If we take into consider the first option, then the next point is does he eligible for reappointment? Does he eligible for reappointment? Uh, yes, whether he is eligible for reappointment, that is specifically mentioned that there is a question. There is a very genuine question that whether he is eligible for reappointment. So the answer is, in my point of view, he is not eligible for reappointment because of the reason that because there is a specific time prescribed for a governor. You know that 5 years. But what happening? What happening? One person is appointed as a governor in one state, and after 2 years, he is appointed in another state, and in after 3 years, he is appointed in another state. So what will happens? His tenure of office commences from the date of appointment. So, for example, the Mizoram governor, for example, a Malayali, as you know that the BJP, former BJP president, advocate that
Sridharan Pilla.
Yes, Sridharan Pillai, who was appointed as a governor of the Mizoram in, I think, in 2019. And in 2021, he was appointed as a governor of the Goa. So his tenure of 5 years comes from 2021. So he is getting another 5 years. So the total period is 7 years. What is actually happening? So in my point of view, that because as you know that this is a democratic country where you know that nobody can appoint in a particular democratic institution for an unlimited period of time. If he is appointed as for a period of unlimited period of time, it will weaken the democracy. So that is, there is no doubt about it. This is actually happening. This is actually happening. So in my point of view, he is not eligible for reappointment for any other post. Once he is appointed as a governor in a particular state, he has to complete there for a period of 5 years. And after that, he is not eligible for the reappointment as a governor in any other state. So that is a important point. And does he eligible for a new assignments? So that was also mentioned by the Sarkaria Commission, because the Sarkaria Commission said eligibility for future offices. Our attention has been, because the Sarkaria Commission consulted all states, all state governments. And what was the conclusion of Sarkaria Commission? Sarkaria Commission said our attention has been drawn by some state governments to the behavior of a few governors. This is there in the Sarkaria Commission report. I have taken all these from the Sarkaria Commission report. To the behavior of the few governors is actively lobbying for a political appointments. This is the matter of grave concern. It is difficult for a governor with such possibilities of the function, specifically in his discretionary space. That is very important thing, the discretionary space. And in an independent and impartial manner, if he looks forward to being given other public office or to resuming his political career at the end of his term as governor. So I think I'm not blaming any particular political party, but the city, you know that many politicians are appointed. Only the politicians are appointed as the governor of the state. Only the politicians are appointed. You please take into consider whether it is the Congress government or whether it is the BJP government, any government, they are only appointed senior politician as a governor of the state. So the governorship should be really the last lap of the journey of a politician. If governor become a minister or hold other official position, the dignity of the office is married. and two state governments feels that the governor should not be appointed for a second term, whether in the same or in another state. Another state government is of the view that a person who has served as a governor should be ineligible for further appointment in any capacity under the union government or the state government. He should also not take any private appointment, because this is what the lawman sir said. Because what the constitutional intention, as mentioned by the constitution, that governor must be an independent, impartial, unbiased person, having a great capability of statesmanship, and he is free from all party politics. That is the constitutional vision. That is the constitutional vision, because constitution is a very people's document, which is very inclusive, very tolerant, very compassionate. So it is the duty of a governor to inculcate all these qualities. So that is that is the most important thing that I found. So I answered all these questions by analyzing the Indian Constitution and the Sarkaria Commission report. So
Excuse me, sir.
Yeah, I will complete within 1 minute. Yeah.
Oh, okay, sir. Thank you.
1 minute. Yeah, thank you very much. So the only 2 points. Discretionary power of the governor. So as already Lawman sir said, the governor will use his discretion properly in accordance with the spirit of the constitution. The draft constitution provides that a choosing his ministers and his relation with them, the governor should be guided by the instructions set out in a schedule. You please note that schedule. But the schedule was subsequently deleted by the Constituent Assembly. While doing so, it was explained that the governor had to act on the advice of his ministers. That is one point. Then second point is, if there is a discretion, then the governor can exercise discretion. The following articles of the Indian Constitution saying that the governor can independently exercise his discretion. And also another point, I would say that all the functions of the governor is subject to the aid and advice of the Council of Ministers. If it is not so specifically mentioned, then the governor is not bound by the aid and advice of the Council of Ministers. For example, Article 191 deals with the disqualification of the members of the legislature, and who is responsible for decide. The governor is the final word as far as the disqualification of the members of the legislature is concerned. But before taking any decision, the governor, by virtue of Article 192, has to consult with an election commission, where he is not bound by the advice of the Council of Ministers, but he is bound by the advice of the election commission. So even otherwise, the governor is bound by the governor's function, executive, legislative, judicial function. Everything is bound by the aid and advice of the Council of Ministers. So I conclude my speech by mentioning one of the most important quote of Dr. B.R. Ambedkar, the father of Indian Constitution, that he said the constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people has yet to learn it. But unfortunately, we must realize that our constitutional institution have yet to learn it. Democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. This conflict is happening because of the simple reason that our democracy is essentially undemocratic. Because as Ambedkar said, democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. That situation is still prevailing. I don't know what is the reason. One of the reasons that I honestly believe that it is because of lack of constitutional literacy. Thank you very much. Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is, I think, is a constitutional